All right, everyone, get ready, because today we are diving into a case, and this one is a doozy.
Oh, yeah, this one's got it all.
Kidnapping, robbery, murder. We've got constitutional law coming at us from every angle.
It's a wild ride, that's for sure.
So to set the stage, we're looking at a U.S. District Court opinion.
Right, and it's denying this petition for a writ of habeas corpus.
Which is basically a last-ditch appeal.
Last-ditch effort, yeah. Kelvin Leerdam is the petitioner, and he is saying his constitutional rights were violated. And we're going to unpack all 6 claims.
6 claims?
6 claims.
Okay, so clearly he feels like he got a pretty raw deal.
He's certainly making that case, yeah.
Before we get into all the legal arguments, though, I think it's helpful to set the scene. We're talking about a 2006 incident. Takes place at a Holiday Inn.
Sounds kind of normal so far.
Yeah. Not your typical Holiday Inn stay, though.
Not even close.
This happened in Fort Lee, New Jersey, and it ended with 2 men kidnapped and robbed. And tragically, one of the men, loses his life.
Yeah, so we're not talking petty theft here. The victims, Alan Plowden and David Taylor, they were known to have money.
Oh, so they were targets.
They like to flash it around a little bit, you know?
Okay.
And it seems like that's what painted a target on their backs, unfortunately.
Yeah, that'll do it. And this is where things get interesting, I think, right? This is where Gina Conway enters the picture. She's an exotic dancer.
Right.
She's entangled with Plowden.
Right.
And also with Charly Wingate, who, depending on what you read, is either her brother or her stepbrother.
It's a little murky. Yeah, their relationship, not totally clear there, but either way, she spills the tea to Wingate about Plowden's wealth.
Ah, okay.
Oh.
So she's the link.
She's the connection.
Okay.
Yep.
And so they hatch this plan.
And it's not exactly Ocean's 11, you know, it's not a smooth operation.
Things get a little messy.
From what we can piece together in the court documents, this whole thing at the Holiday Inn it spiraled really quickly from a robbery into just this chaotic, violent encounter.
And that's when David Taylor is killed.
Right.
Man. Okay, so this is heavy stuff from the get-go. So then we end up with Kelvin Leerdam and Charly Wingate. They're kind of our main players, right?
Yeah, they emerge as the key players. And they're both hit with a slew of charges related to this incident. Everything from kidnapping to robbery.
Oh, yeah, they're not messing around.
No, this is the real deal. And get this. They're tried together.
Together?
Joint trial.
Oh, man. I bet that complicates things.
You can say that again. Adds a whole other layer to this whole thing.
I'm sure that'll come back to haunt us, or at least be something to unpack as we go here. So, fast forward a bit. They're both found guilty. Leerdam gets a life sentence. But he's been fighting this, right? This is not his first appeal.
Oh, no, he has been busy. Direct appeal, then a post-conviction relief petition. Both denied. So this habeas corpus petition that we're about to dive into, this is it. This is his last shot.
High stakes.
High stakes.
You're telling me. Okay, so let's get into it. Those 6 claims, each one is like a different way that Leerdam's saying, hey, the system failed me.
And these aren't small potatoes. These are like fundamental rights. We're talking about the foundation of how our justice system works.
Exactly. Huge. So where do we even begin?
Well, we can start with claim 1. And this one really hinges on Giselle Neves. Remember her?
She's in the hotel room, right?
Right, with Plowden. So Leerdam is saying that the prosecution, they made a deal with Neves to get her to testify.
Yeah.
But they didn't disclose it. They basically let her lie on the stand.
Ooh, like a legal bait and switch?
That's Leerdam's argument. So follow me here. Neves was initially charged with conspiracy to commit robbery. Pretty serious stuff. But those charges were dropped. After she finished this pre-trial intervention program, it's called PTI.
PTI.
Right? And as a condition of that program, she agreed to cooperate with the prosecution. Testifying against Leerdam and Wingate, that was part of the deal.
But she didn't exactly volunteer that information on the stand.
Nope. During the trial, Neves is up there, under oath, and she says there is no deal requiring her to testify against them. But, and this is where it gets juicy, remember I mentioned that PTI transcript?
Mm-hmm.
That's where the discrepancy pops up. It clearly outlines the terms of her agreement. And cooperation. Mandatory.
Busted. So Leerdam's lawyer, he just like stumbles upon this transcript.
It wasn't quite that dramatic,
Yeah.
but yeah, that PTI transcript throws a wrench in things.
Mm-hmm.
The prosecution, when they're confronted with this, they're basically like, well, we were trying to get truthful testimony. She wasn't bound by any deal at the time that she was on the stand.
But come on, she got into the program because she agreed to cooperate.
Right. Hard to argue with that logic. Leerdam's lawyer was not happy, as you can imagine.
I did not.
So the prosecution, to their credit, they do offer to have her recalled. So Leerdam's lawyer could cross-examine her about this whole PTI thing. But what ended up happening is they just read a stipulation to the jury, basically summarizing the terms of her agreement.
Okay, so at least the jury knew, even if it was kind of after the fact. Did it matter? What did the court say?
The court acknowledged, yes, the state, they have a duty to disclose evidence that could be favorable to the defendant, especially if it calls into question a witness's credibility. But because Leerdam's attorney had the opportunity to use this information during the trial,
Okay.
and because there was other evidence pointing to Leerdam's guilt, the court's like, this late disclosure, it's not enough to overturn the conviction.
Still, though, shady.
Yeah. Doesn't exactly inspire confidence, does it?
Not really. All right, claim 2. This one's all about eyewitness testimony, right? Always a slippery slope.
Oh, yeah, this is a big one. So buckle up, because this is where the case really hinges on two people. Plowden, who survived the ordeal, and Mbenga, the taxi driver.
Right, right.
Leerdam's arguing that their in-court identification's not reliable. He's basically saying they were influenced by the courtroom setting itself.
Okay, so let's break it down. What happened with Plowden?
All right, so Plowden, he'd been shown these photo arrays before, sets of photos of potential suspects.
Lineup, but pictures. Got it.
Exactly. And he could not positively identify Leerdam
Right.
from those photos. Yeah. In fact, he even picked someone else entirely.
Whoa. Okay, so red flag number 1.
Right. But he did say at the time, he's like, look, I'd rather see these guys in person. The photos weren't clear enough, so they get to court. And Leerdam's lawyer totally objects to him making an identification right there in the courtroom. Understandable.
Oh, yeah. I mean, talk about putting someone on the spot.
Right. You've got Leerdam sitting right there next to his attorney. It's suggestive.
Totally.
So the court's like, okay, let's hold a Wade hearing.
A Wade hearing. Is that like a legal term for a timeout?
Kind of. It's basically a midi hearing within the trial. The judge listens to arguments and looks at evidence to decide if an identification was fair. Was it overly suggestive or not?
Got it. Like a safeguard.
Exactly. So during this Wade hearing, Plowden, he is adamant. He's like, no, I got a good look at Leerdam during the crime. He said he saw his face when he woke up in that hotel room.
Oh, gosh, yeah.
Leerdam was pointing a gun at him. Even though Leerdam told him not to look at him, Plowden's like, nope, I saw you again later after I got some of the duct tape off my eyes.
I can't even imagine. But how much can you trust a memory made under that kind of stress? And what about that photo array where he pointed to the wrong guy?
Right. Those are the million-dollar questions. And that's what the court had to grapple with. They're looking at the photo arrays. They're thinking about how long he saw him, the circumstances, all of it.
Yeah.
And they ultimately decided to allow the in-court identification.
Really? Even with all of that?
They did. They were convinced that he had enough of a chance to see Leerdam during the crime, and that photo array didn't totally invalidate this in-court ID, especially because he was so sure.
Wow. Okay, what about the taxi driver, Mbeng? That feels even more iffy, right? He hadn't even seen photos.
Exactly. He's never seen a photo of Leerdam before. So Leerdam's lawyer is arguing that, come on, this is way too suggestive. He's never even seen him in a lineup before.
Did they at least do a lineup then? Just to be sure.
They didn't. And this is where it gets interesting. They actually pointed out that Leerdam hadn't filed any pretrial motions about Mbengi's potential identification.
So because it wasn't addressed before, it's like it didn't matter.
Basically. Plus, they said there was no legal precedent that said a witness who had spent significant time with a suspect couldn't make an in-court identification.
So even though he'd been with him in the taxi hours, presumably, they're saying that doesn't make it less reliable.
That's how they saw it. It's tricky, right? Because you could also argue the opposite. If you've been with someone for hours, maybe that makes it harder to separate them from the stressful event itself.
Right, like your memory gets muddled.
Exactly. And this goes to a broader point about eyewitness testimony. Our memories, they're not always as reliable as we think they are. And these identification procedures, they can really influence what we think we remember.
Man, this is making me question everything.
Right. It's fascinating and a little unsettling.
Yeah.
But to answer your question, they did let Mbeng make that in-court ID.
Wow, okay.
And just like with Plowden, the appeals court, they sided with the trial court. They emphasized that the jury, they would have been given those standard instructions about eyewitness testimony, like don't put too much stock in in-court identifications.
Okay, so 2 claims down, and so far not looking good for Leerdam. This next one, though, claim 3. This is where we really get into the weeds. We're talking hearsay, right? To confront your accuser. And that whole joint trial thing comes back to bite us. Hit me. Okay, so Claim 3, this is where we're getting into hearsay and what was it? Right to confront your accusers.
Right to confront your accuser.
Which feels like a pretty big deal.
It is. And you know that joint trial we talked about? It rears its ugly head again.
I knew it. Okay, what happened?
So because Leerdam and Wingate were tried together, the prosecution was able to use some statements that Wingate had made to other people.
Oh, like things he had said about the robbery plan?
Yep, exactly. But here's the thing. Wingate, he never actually took the stand himself.
So they're just using his words against Leerdam even though he's not there to, like, defend himself?
That's what Leerdam's arguing. He's saying that because he couldn't cross-examine Wingate about these statements, it violated his Sixth Amendment right to confront his accuser.
Which, yeah, seems pretty fundamental to me. If someone's going to use your words against someone else, you should get to be like, hey, wait a minute, that's not exactly what I meant, or whatever.
Exactly. But here's the catch. And you knew there was going to be a catch, right? There's an exception to that whole hearsay rule when it comes to statements made by, get this, co-conspirators.
Co-conspirators. So basically, if you can prove they were in on it together.
Exactly. If someone says something in furtherance of a conspiracy or a crime that you're both involved in, then boom, those words can be used against you, even if that person never takes the stand.
Wow. That's a pretty big exception.
It is. So in Leerdam's case, the court really leaned on the fact that there was already a lot of evidence suggesting a conspiracy. You know, you had Leerdam, Wingate, and Conway. They each had their own reasons for wanting to rob Plowden. Their actions, they all lined up with this plan.
So the court's like, look, we're convinced they were all in cahoots, so these statements are fair game.
Pretty much. They even said that even if admitting some of Wingate's statements was an error, it wasn't a big enough error to overturn the whole thing. Because remember, there was other evidence pointing to Leerdam's guilt.
Okay, so they're basically saying, yeah, maybe we bent the rules a little, but it doesn't really matter because he was guilty anyway.
That's a bit of a simplification, but you're not far off.
Okay. Moving on. Claim 4. This one always blows my mind. Leerdam's claiming his own trial lawyer was ineffective.
Yeah, it's not uncommon. It's a bold strategy for sure. Because to actually win on that claim, you have to prove that your lawyer messed up so badly that it actually changed the outcome of the trial.
So high bar to clear. What his lawyer do that was so awful?
Well, according to Leerdam, his lawyer basically promised the jury that she would bring in these witnesses who could point the finger at other potential suspects. But then she never did.
Oh, so classic. Someone else did it, defense, but she didn't have the witnesses to back it up.
Right. It's the same group of people she mentioned in her opening statement: Castro, Neves, Cruz, and Blancaneaux. I know, a lot of names to keep track of.
It's like a bad soap opera up in here.
Right. Leerdam says these witnesses, their testimony would have shown that there were other people with motives to rob Plowden and Taylor, that the cops just had tunnel vision on them.
Okay, so what happened? Did these witnesses disappear, fall off the face of the earth?
You'd think there'd be a more dramatic story, right? Like they're all on a beach somewhere sipping Mai Tais.
Yeah.
But honestly, the court records are really vague about why they didn't testify. We know Leerdam's lawyer told the judge she couldn't find at least one of them, but that's about it.
Really? That's all we get.
It's frustrating,
Yeah.
Right? But the court, they kind of glossed over it. They said that, first of all, his lawyer didn't actually make any promises about what these witnesses would say, just that the jury would hear from them. And secondly, even though those specific people didn't testify, the jury did hear testimony from Neves that confirmed these other folks had at least talked about robbing Plowden at some point.
So it wasn't a total blackout of information, just not from those specific people.
Right. It's a fine line. And in the end, the appeals court decided that the missing witnesses, it wasn't enough to make the trial unfair.
Okay, so 2 claims left. What's next?
Claim 5 is interesting. Leerdam's arguing that the lawyer who represented him in his first appeal attempt, remember I said this was separate from the direct appeal, he's saying that lawyer was ineffective too.
Wait, so both his lawyers were incompetent? Is he just really bad at picking lawyers, or is something fishy going on here?
Right. You have to wonder. Anyway, this time he's saying the lawyer messed up by not getting those affidavits from his alibi witnesses.
The alibi witnesses, didn't we already establish those were kind of shaky?
Yeah, the court wasn't buying it the first time around. That's why I said this claim feels a little repetitive. And the court basically agreed. They pointed out that there's no constitutional right to a lawyer for those post-conviction relief proceedings. So even if the lawyer had made mistakes, which, by the way, they didn't actually rule on, it wouldn't automatically invalidate the outcome.
So even if he tripped on his shoelaces and fell flat on his face, it wouldn't have mattered.
Pretty much. Okay, last claim, claim 6. Leerdam saying he was denied due process because the courts denied his requests for hearings.
Hearings about what?
Hearings related to his post-conviction relief petition and also a separate motion for a new trial, both of them based on those alibi witnesses again.
Okay. So he's not directly arguing those claims anymore. He's arguing about the process itself. Like, he didn't get a fair shot to make his case.
Exactly. He's saying, hey, even if you don't believe my alibi defense, and I know you don't, at least give me a chance to properly present those arguments. He's shifting the focus from the outcome to the process.
Okay, I get it. So what did the court say?
Not what he wanted to hear. They said this kind of procedural argument, it doesn't usually fly in a habeas corpus petition. Which, remember, that's about whether someone's being detained illegally, meaning their constitutional rights were violated in a way that put them in prison.
So this is more about how his appeals were handled, which doesn't fit neatly into that habeas box.
Exactly. And even if they did consider the argument, they weren't convinced that a hearing would have changed anything. They already decided those alibi witnesses weren't strong enough to justify a new trial. End of story.
Wow. So there you have it. 6 claims, 6 swings, and he struck out every time. This case is a wild ride, I'm not going to lie. It's one thing to talk about these legal concepts, but seeing them play out in a real case with such high stakes, it's really something else.
It makes you think, right?
Yeah.
This wasn't just about whether one guy was guilty or innocent. It raises all these questions about how our justice system works, how much we can trust eyewitness testimony, what happens when you have a joint trial. It's complicated.
It's super complicated, and for anyone listening, I think that's something to really sit with. This case might be closed, but this conversation about justice, that is far from over. Until next time, everybody, keep diving deep.